Hi, and thanks for joining me on today's legal Q&A. So the first question that we received is as follows. When a defendant is served by the U.S. Marshals Service, is there a 21-day period that they must respond to the U.S. District Court? Now, what this question is asking is, after a plaintiff files a complaint, in federal court, there's a 21-day period within which that the defendant must serve some sort of responsive document, whether it's an answer or a motion to dismiss or some notice that they're appearing in this matter. And so this question is really asking, what happens if they don't file an answer within the 21-day period? The fact that it's being served by the Marshal's Office doesn't really have much impact on this question. The real question is what happens if you don't respond in the 21-day time period. Well, the answer is simple. If there's no response whatsoever, no letter to the court, no notice of appearance, no answer, no motion to dismiss, then the plaintiff has a right to seek a default judgment against the defendant who has failed to enter an appearance. So the answer to this question is there's no extra time given if the complaint is served by a process server or the Marshal's office. What happens is that if they haven't made an appearance after the 21 days, you have a right to file for a default judgment. The next question, I paid off a judgment after 5 days. The judgment was entered in the Superior Court of New Jersey in Trenton. It is not appearing on the docket. It is still showing on my record, and I would like to know how to get this removed from my public record. All right, let's take one thing at a time. So there was a lawsuit and there was a judgment that was entered against this individual, and he or she paid the judgment in full. So in other words, satisfied the judgment. And as part of that satisfaction of the judgment, there would be a document that would be filed with the court, alerting the court to the fact that the judgment has now been handled and resolved, paid in full, if you will. But that doesn't invalidate the fact that there was a judgment out there, and legal proceedings are generally matters of public record. Therefore, someone could go to the courthouse and they could pull the file for this individual case and see that a judgment was entered. Separately, this could appear on credit, through credit reporting agencies and other websites online that do background checks on people and that sort of thing. So the fact that a judgment was settled and paid in full, that doesn't necessarily mean that you can protect or guard against that being part of your public record. Now, in rare circumstances where a case involves a minor, a child, or there's some sort of confidentiality order that had been issued, then such matters, and depending upon what the parameters of the confidentiality are, would be sealed and not be a matter of public record. But in this case, just because you paid off the judgment, it doesn't mean that it's not going to be on your quote-unquote public record. As for the sub-question, which is I paid it and it's not registering in the court's docket, well, the courts can tend to move slowly, even when you're entering something as simple as a warrant to satisfy judgment or something like that. So be patient with that, and if you don't have some sort of confirmation that it was entered, call the court clerk and just confirm with them. All right, the next one. I had an oral lease, and now the owners are in bankruptcy, saying that I am a trespasser, and they've obtained an eviction notice from the judge. All right, so what I gather from this question is that the person asking the question is a tenant and did not have a written lease, but rather a verbal lease, and the owners of the property have now filed for bankruptcy, and a judge has ordered them to vacate the premises. So this raises a lot of interesting questions. Well, first of all, we need to know more before we can really answer this question. In New Jersey, if you are a tenant and you are residing with the owner of the property, so in other words, the owner lives on the first or second floor and you live on the other floor, the owner has far more rights and abilities to get you to move out of the house than if you're in, let's say, a garden apartment that's owned by a company or property management or whatnot. But that's not even what we have here. We have bankruptcy. there's a verbal lease. So if it's a verbal lease, a non-written lease, it generally means that you have a month-to-month tenancy. And the owner of the premises can ask you to vacate with 30 days notice. Now, the fact that a bankruptcy proceeding had been filed, the tenant should have known well in advance of this eviction notice that they were filing for bankruptcy and that they might have to vacate the premises. So in this instance, without more information than what we have in this question, I would have to say that the tenant is going to have to abide by the judge's eviction order and should probably start looking for another place to live ASAP. All right, now this next one's a custody question. Will custody be granted to my son's father? And this is an interesting question. What we have here is a 17-year-old mother who is attending full-time a school that's designed for women who have infants, teens that have had babies and that they need to take care of them. So it's a special school. And her husband is now filing an application with the court for sole custody of the child. And her concern is what's going to happen. What are the grounds by which someone can request sole custody, and how likely is it that it will be granted? All right, so first I have got to say that in general, it is very difficult to obtain sole custody of a child unless there's something specific that has happened. So for example, whether it was some sort of mistreatment or neglect or abuse, those would be reasons why the court would want to award sole custody to someone else. But generally the courts favor joint custody. They like to see the parents involved in the kids' lives and working things out. And so the courts typically favor that. Now, there's no indication in this question that there's any abuse or alleged abuse on the part of the mother, simply that she's 17 years old and goes to school full-time. But that doesn't seem to me to be enough to say, sole custody should be awarded to the father. We don't know enough about the father. We don't know where he lives, how old he is, whether or not he's employed. So without knowing more, I would venture to guess that the courts will not award sole custody to one or the other parents. The fact that she's a teen, in this case, seeing that she's acting responsibly, going to a school that accommodates her child care needs, I think that the courts are going to just continue with joint custody. All right, now here's another interesting question. This one says, is it lawful to terminate an employee that notified his company of a need of major surgery and then be fired while he was out of the country on bereavement leave? All right, so there's a lot going on here, but what it boils down to is that there's a company who has an employee, and the employee has had some medical testing done and now has learned that he's going to require some surgery. And while he is preparing for the surgery, there's a death in the family, and he has to leave the country to go deal with the death in the family and the funeral. While he is gone, he is fired. His question is this lawful to do it when the employer knows that he needed surgery? And the answer really is it depends. So if you're an at-will employee, meaning you're a non-contract worker, you're not in a union, you haven't signed a contract with your employer that sort of guarantees the time period that you're going to be employed, you are an at-will employee. I think it's something like 90% of the people in this country are at-will employees. So if you're an at-will employee, you can leave your job or your employer can fire you at any time for any reason. The only time that you cannot be fired, where it would be unlawful to be fired, is if the employer fires you for some discriminatory reason. Okay, either on the basis of your sexual preference, your race, your creed, your religion, a disability. Then you might have a claim for discrimination. In New Jersey, it would be under the LAD, the Law Against Discrimination. You may even have a federal claim. But based upon the information provided in this question, it seems to me as though he was fired probably for a non-discriminatory reason. And so it's not clear here that discrimination was at the heart of the decision to terminate him. Now, you'd have to delve into this, and if he believes that they fired him on purpose simply because of the upcoming surgery, then he should of course file a lawsuit, and that information as to why they fired him would be discovered throughout the course of the case. But just based upon this alone, you can't really tell if they're firing him for some discriminatory reason. Now, that being said, there's nothing that prevents an employer from terminating an at-will employee who is habitually late to work or constantly out sick or any of those things. So, there's not enough here to be able to determine that, but it certainly is something that is a common question that we see. Okay, and today's final question is it possible, and how could I start a charity account for pro bono lawyers to use? Now, the author of the question is looking to establish a fund that pro bono lawyers can use to assist their clients in connection with filing fees and depositions and that sort of thing. So the author is trying to establish some sort of charitable foundation or entity and have pro bono lawyers work out of that company and provide assistance to those in need. But what the question forgets to touch on is, before you can set up an account, you really need to have a designated not-for-profit company established. Because if you just set up an account, A, you might not be able to, B, you're going to be paying taxes on it because it's not a properly set up 501c3 or c4 entity, and you're going to end up having some liability as well. So the answer to this question is, before you get into setting up an account, what you really need to do is sit down with an attorney and let the attorney help you establish a properly formed not-for-profit corporation. And then you'll be able to create a bank account, you'll be able to accept donations, you'll be obviously tax exempt so long as you meet the requirements of a 503c or 4 entity. So that's all we have for today. If you have questions of your own and you'd like them answered, please post them either on the comment section below, on our Facebook page, on Twitter, or you can call us at 973-949-3770 or email me at info@peterlamontesq.com. Thanks for joining me. I'll see you next time.